All right, welcome everyone. Assuming now we're good? Can you make sure that this is actually on? I don't know that it is. Can everybody in the back hear me? Somebody in the last row wave and tell me you can hear me. Very good, thank you very much. Before we begin, I wanted to take a moment to reflect on the land on which the University of Toronto operates. I came to the University of Toronto some 25 years ago and to Canada some 10 years before that. And in this time, I have learned a lot about the history that has brought us here. And so I wish to acknowledge that for thousands of years, this has been the land of the Huron-Wendat, the Seneca, and the Mississaugas of the Credit. And today, this meeting place is still home to many Indigenous people from across Turtle Island, and at the Faculty of Law, we are grateful to have the opportunity to learn, work, and build community together on this land. And in this spirit, a very warm welcome to the 2024 Grand Moot. I think definitely the most popular event in the annual Moot calendar, and not only that, this U of T law tradition is a highlight in the academic year because 4 of the law school's most skilled mooters make their submissions to a distinguished panel of Canadian judges. The problem that we will hear the mooters engage with tonight is timely, to say the least, the federal invocation of the Notwithstanding clause in the criminal context. And we are very lucky to have with us tonight a wonderful bench, if I could say that word, that would be good, bench of Grand Moot judges, the Honorable Justice Suzanne Cote of the Supreme Court of Canada, the Honorable Chief Justice Michael Tulloch of the Court of Appeal of Ontario, and the Honorable Justice Ira Pargi of the Ontario Superior Court of Justice. And our Grand Mooters are Joshua Schwartz and Naya Sheth for the appellants, and Bryn Dalmao and Emily Chu for the respondents. I also want to be sure to acknowledge, and I can't see them at the moment, but our Moot Court Chief Justices, Ria Thomas and Vidit Desai, they have done, needless to say, and many of you know this already, but they've done all of the heavy lifting in the planning for this evening. They've worked tirelessly on literally myriad tasks, large and small, and among the smaller ones were things like drafting the problem and coordinating drafting of the factor, writing the bench memo, making sure that submissions went in timely fashion to the justices, and just organizing this whole event. So we're very grateful to them, and we're also grateful to the law firm sponsor and gracious host of this evening, McCarthy Tetro, and here Liliana Stanic, Holly Kalmeyer, and Chris Puskas worked hard on helping organize the Grand Moot, and Rachel Chan and Robin McKechnie were very helpful in preparing. The Mooters also would like to thank a number of faculty members who were extremely helpful in developing the problem and the responses, and I do this in the order in which it's given to me. That's Richard Stacey, Jean-Christophe Bédard-Robin, Joseph Cheng, who is an adjunct faculty member with us, Martha Schaefer, Hamish Stewart, Anna Sue, and our law librarian, Alexia Lumankis. Also, many, many thanks are owed to our Assistant Dean, Sarah Farity, who oversees the coming together of this event every year, and without whom it would not come together in the way that it does. And our events team, Aviva Lef Aviv, who also devoted hours to making this evening run smoothly. So please join me in welcoming our 2 Chief Justices who will have some more opening remarks for you.
Welcome all. Bonjour et bienvenue. Thank you so much for attending the 2024 Grand Moot at the University of Toronto Faculty of Law. My name is Vidit Desai, and this is Rhea Thomas, and this year we've had the unique pleasure and distinction of serving as the Chief Justices of the Grand Moot. We want to start by echoing Dean Brunet's thanks to our generous sponsor, McCarthy Tetro, without whom this amazing event would not be possible. In particular, we'd like to thank Chris Puskas, Liliana Stanic, as well as Holly Kallmeyer for all of their help in planning this event, as well as judging the various run-throughs for the Mooters. We would also like to thank, in particular, the Grand Moot bench clerks, members of the University of Toronto Faculty of Law student body, who have spent countless hours doing background research and helping with some of the logistics for today, specifically Matthew Farrell, Akash Jain, Audrey Wu, Kit Sellinger, and Georgia Gardner. And last but not least, we owe a tremendous amount of gratitude to all of the members of the Faculty of Law who have helped make this event a success. This includes Dean Brunet, Assistant Dean Faraday, Events Coordinator Aviva Levaviv, as well as all of the professors who have volunteered their time to consult on this problem and assist the Mooters. We are tremendously grateful for all of your help. At this time, we would like to ask all members of the audience to put your electronic devices on silent, as well as to refrain from leaving the moot courtroom while the Mooters are presenting so as to avoid interruption. I will now turn the floor over to my fellow Chief Justice to provide a brief summary of tonight's problem.
Good evening, everyone. The appeal that you'll hear tonight takes place in Flavel, a country that is functionally equivalent, legally and historically, to Canada. The Mooters will explore the nuances of the federal government invoking the Notwithstanding clause from the Charter of Rights and Freedoms in order to pass gun control legislation. The legislation in question is called the Firearms Safety and Accountability Act, or the FSAA for short. The FSAA amends the criminal code by adding Section 94, which prohibits knowingly possessing an unauthorized firearm in a motor vehicle. David Thomas is a truck driver who lives in the province of Falconer. He is charged and convicted under Section 94 of a summary offense and is subject to a driver's license suspension that prevents him from driving in a province in which he does not hold a valid driver's license. The suspension is for a period of 4 years. Section 94 also includes that the penalties for the offense are operative notwithstanding rights set out in Section 7 and 12 of the Charter. In response, David Thomas challenges the constitutionality of the FSAA on the following grounds. First, he argues that the federal government did not properly invoke the Notwithstanding clause through the FSAA because they intentionally excluded the word liberty set out in Section 7 of the Charter. Second, he submits that the FSAA does violate his Section 7 Charter rights because his liberty interests are infringed in a matter that is not in accordance with the principles of fundamental justice. Finally, he argues that the interprovincial license suspension incidentally infringes his mobility rights set out in Section 6 of the Charter because it prohibits interprovincial travel. He further argues that these violations are not saved by Section 1. Today, the Supreme Court of Flavel will hear the parties' submissions. We are very, very fortunate to be joined tonight by the Honorable Justice Suzanne Cote of the Supreme Court of Canada, the Honorable Chief Justice Michael Tulloch of the Court of Appeal for Ontario, and the Honorable Justice Ira Pargi of the Ontario Superior Court of Justice. We will now cede the floor to the Grand Mooters, Joshua Schwartz, Nevya Sheth, Bryn Dalmeo, and Emily Chu.
please be seated. So, in the case of David Thomas against the Attorney General of Flavel, are you ready to proceed? Mr. Schwartz for the appellant.
Good evening, Chief Justices, Justice. My name is Joshua Schwartz, and along with my colleague, Navia Sheff, we are here on behalf of the appellant, David Thomas. On one hand, this case appears small. It involves one man who made one mistake, kept from doing one thing, driving freely across the nation. But on the other hand, this case is immense. 2 years ago, Parliament invoked the Notwithstanding clause to enable a criminal punishment suspending one's ability to drive freely across the nation. That is, the federal government, for the first time in history, used this most exceptional and invasive constitutional power to allow criminal law to override fundamental charter rights. Ultimately, this case is about freedom and the care the state must take when it makes the extraordinary decision to take it away. The preciousness of what is at stake, where the Notwithstanding clause is invoked, means that any ambiguity must be construed strictly in favor of maintaining our rights and freedoms. My co-counsel and I have 3 submissions this evening. First, Parliament omitted the right to liberty from its invocation of the Notwithstanding clause. This court respectfully cannot put it back in. Second, accepting that the invocation was deficient, Mr. Thomas's Section 7 right to liberty was engaged, and the law was overbroad in taking it away. Lastly, as my co-counsel will submit, prohibiting Mr. Thomas from driving across provincial borders violated his Section 6 rights to mobility and to pursue a livelihood in any province, and neither of which can be demonstrably justified in a free and democratic society. Beginning with our submissions on Section 33, which you can find at paragraph 22 in the written factum. In omitting the right to liberty from an enumeration of rights to be suspended, the impugned invocation should be read to exclude the right to liberty. Section 33 in its text requires that any right intended to be overridden must be expressly declared in the Act of Parliament.
Mr. Schwartz, I'm sorry to interrupt you. Don't see anything in that, but I understand your point. But what do we do with the catch-up sentence, which is in the Act too?
The all other rights therein
Yeah.
clause? That's the question I'm dreading, and it's what exactly this case has to do, because if, as we know from Ford and Quebec, that if the Parliament had only invoked Section 7 or Section 12, that would be sufficient. It would catch all of the rights and freedoms contained therein. However, Parliament then undertook to specify which rights it intended to override. And here we'll bracket Section 12 because there's no issue with that invocation. And it specified the right to life and the right to security of the person, omitting the right to liberty. So here what we have is an undertaking by Parliament, in accordance with paragraph 33 of Ford and Quebec, that it doesn't intend to catch the entire charter provision, but only certain rights. But per your question, Chief Justice, what do we do with the residual clause at the end? All other rights therein. In one sense, this question has to do with what therein means. Where, if we think about diagramming sentences as we did back in school, where's therein point back to? We would submit that therein cannot point back to the original numbers, thereby scotching the particularization, because we presume that Parliament does not write or draft in vain. Otherwise, that particularization would be purposeless, mere surplusage.
But I would agree with you if we would not have, let's say that we would have the right to security, this omission of, about liberty, but no catch-up sentence. I would agree with you that it's a clear omission, and it cannot be, if I follow the test in Ford, it cannot be repaired, let's say. But in this case, we have that catch-up sentence, and we have to give meaning to that too.
Indeed. So we would submit here that in accordance with BC motor vehicle reference, that Section 7 must be construed as a unified or unitary provision. There's not two rights, right to life, liberty, security of the person, and the right not to be deprived therein except in accordance with the principles of fundamental justice. But here we have another aspect of the right that was not mentioned in the invocation, the principles of fundamental justice. And these are not mere principles, because in Seaboyer we know, for instance, that some of them, for instance, the right to a fair trial, the right to a full answer in defense, are characterized as rights. And their purpose is to ensure that when the state opts to deprive someone of their life, liberty, or security of the person, that it's done in accordance with these protections. So all other rights therein, thus, refers to the principles of fundamental justice that serve to protect the life and security of the person that Parliament enumerated in the invocation, thereby leaving liberty excluded even from that residual clause. And I'm glad, and thank you for that question, because now we got into the meat of the matter. In some level, this is a question of statutory interpretation. We need to make sure that the words there make sense and that they cohere. But also, by your leave, I'd like to zoom out a little bit and try to think about what Section 3 asks and what it demands of a legislature. In its essential requirement of form, we would submit that because of what's so precious at stake, namely the charter rights and freedoms, which, as the concurrence in the Hawke appeal recently stated, are precious and well fought, that the essential requirement of form requires a legislature to be precise and careful in its language. It is only where there is a lack of ambiguity that a court, as the guardian of the Constitution, can ever presume that a legislature intends to override a charter protection. After all, as we know from Hunter and Southam, the purpose of the charter is not to authorize government action, but rather to protect the individual from government overreach. Now, it's the case that Section 33 enables a government to allow legislation to operate.
So are you then saying that we should have a different standard interpretation within criminal cases as opposed to other contexts or cases?
We do submit that as the case, yes. On Section 33's own terms, we submit that it should be construed strictly, maybe departing from the general approach of a more purposive and liberal. That where it's invoked in the context of criminal law, it should be. This, I must admit, it's a novel argument, but one I worked really hard to come up with. But I think we can defend it on these grounds.
You're doing a great job.
Yeah. Thank you. But no, and you're quite right to note, Chief Justice, that this isn't common, but it's because this has never been done before. A government has never invoked Section 33 to allow criminal law to operate, notwithstanding charter protection.
But Mr. Schwartz, you say, let's say that this strict construction principle does apply, although it's a novel question and you have no binding authorities on that. So you are asking us, based on that strict construction, to give more meaning to the omission of a word than to give meaning to existing words. And you will say that I have a fixation on this catch-up sentence, but you are asking us to say a word is omitted and this is the end of it, and you're asking us to ignore the balance of the provision. So I am trying to understand how you can reconcile that with the strict construction principle.
I recall the case of Marcotte, which is from a while ago, but therein the court said that where liberty is at risk, if it's not to be deprived according to express terms, it cannot be deprived by implication. Here, the omission is glaring. It's the three most common phrased words in the Charter: life, liberty, security of the person.
Counsel, is
Yeah.
it the notwithstanding clause?
The notwithstanding clause has the power to override fundamental rights, which includes the right to liberty.
That's the whole idea of
Indeed. But liberty is such a precious interest that from time immemorial, courts have never been lax or lenient when it comes to the potential for it to be deprived in the instant case. So here, back to your original question, Chief Justice, we would submit that because Section 33 instructs a legislature to include the invocation in an act of Parliament or legislature, thus the governing principles that help us interpret that kind of legislation must be applied. And when it's in the case of criminal law, after a purposive construction of the provision, if there is, quote, true ambiguity, courts have held that we must construe any ambiguity in favor of the accused and the maintenance of their individual liberty. Now, in criminal law, that's conventional because that's exactly what's at risk, unlike in other legal subjects.
But why Parliament would invoke the notwithstanding clause if the aim was not to engage liberty? Is it not a sign that it was just a mistake, that they did not write liberty in the provision?
I can't step into the shoes of Parliament, and I would never claim that Parliament made a mistake. We presume that Parliament means what it's doing, and indeed, as the first judicial consideration of Section 33 in Alliance des Professionnels stated in the Quebec Superior Court, we can only have what's on the page. We cannot imply in what's missing. Here, too, what we have is that Section 33 commands an express declaration, and according to its own formal constraint, as well as, I would say, in the alternative, in the context of criminal law, where there is ambiguity, we must construe it to ensure that the individual liberty of the accused is not put at risk without clear and express, unequivocal parliamentary intent. To analogize, perhaps, we can perhaps analogize to the piercing of solicitor-client privilege, which according to Blood Tribe also requires for language to be unequivocal, unambiguous, and clear. Without that, we cannot deprive someone of that most fundamental principle of fundamental justice, being able to confide securely with their solicitor.
May I just ask counsel on this topic, one of the dissenting judges below seemed concerned with the fact that this was a federal invocation of the notwithstanding clause and not a provincial legislature's invocation. I'm wondering what your thoughts are on that and whether that should affect the analysis in any way.
On a legal level, Section 33 is clear that it contemplates explicitly Parliament or a legislature of a province. So we don't see there to be grounds, with all due respect to the dissenting justice in the court below, for the federal government to be treated differently. However, we would submit, in line with the question you asked, Chief Justice Tulloch, that because of the context of criminal law, for which a Parliament, the federal government, has unique power, in that case, and its invasive reach into the most precious interests we have, our freedom, because of that, we need to be very careful. If we were to construe this any broadly, then we have clear and unequivocal evidence of what was intended.
Thank you. I imagine we've taken you off of your planned submissions somewhat, so thank you for your indulgence. Go ahead.
Thank you for your consideration, Justice. Moving to our submissions in Section 7, by your leave, if there are no other further questions on Section 33, which you can find at paragraph 43 in the written submissions. Now, first and foremost, I will concede what appears to be the ball game, but I promise it is not. Now, in the vast majority of jurisprudence on the suspension of a driver's license, courts have been bald-facedly clear that the driver's license is not a constitutional entitlement, in line with Hatarian Brethren, for instance, and that suspending a driver's license does not engage the Section 7 right to liberty. Driving is nice, but the Charter doesn't protect it.
So it's not a constitutional document like a passport, like the passport in the case of Prior, for instance.
I will cede all submissions on passports to my co-counsel, who has become an expert in these past few months. However, I would say, though, that it's exactly the case that in the context of how the regulatory framework administers the driver's license, it doesn't attract the same kind of charter scrutiny. However, there's only one case which has considered the deprivation or suspension of a driver's license within the context of criminal law, and that's the case of Sahalouk in the Alberta courts. Now, in Sahalouk, because of the categorical difference that criminal law has distinguished from the mere administrative inconvenience of having your license suspended in a regulatory framework. Because of the potential for true penal sanction, Section 7 right to liberty is engaged if your license is suspended through the workings of a criminal offense.
But in that case, you are referring to the Alberta case. The context was totally different. We were talking about trial conditions where the presumption of innocence was still in play. Here, your client has been convicted and he is not disputing his conviction before us. So we are talking about conditions in the sentence. So I think we should make a distinction because the reasoning in the Alberta case was a lot focused on the presumption of innocence.
Indeed, the reasoning had focused on Section 11D. However, there were separate reasoning in Section 7 that treated the right to liberty on its own, in which case it was still found that even if the suspension of a driver's license does not engage a charter-protected right, for a privilege as fundamental as driving in a nation as spacious as Flavel, which we all know very well exactly what Flavel is like, that driving is so important to get around, and especially someone like Mr. Thomas, whose friends and family live over the provincial border. This is a constraint of his free movement. And when that's done by reach of the criminal law, that is a qualitative difference than a mere, again, a regulatory offense. Here, while it's the case that the prosecutorial discretion prosecuted him as a summary offense, which meant that there's no potential for imprisonment, but still, to be subject to criminal law scrutiny means you now have a criminal record, you'll be treated differently. Criminal law reaches into our lives invasively in a way that no other law can, and because of that, it attracts Section 7 protections most precisely. Now, by your leave, I want to address the question of if we can accept that, let's at least consider that Section 7 right to liberty is engaged. Whether it was deprived, not according to principles of fundamental justice, is a separate question. So, barring any further questions, I'd like to move to that topic, which you can find at paragraph 51 in the written factum.
Go ahead.
A law is overbroad where conduct caught by its provisions does not further the purpose of the legislation. The legislation of the Firearms Safety and Accountability Act is clear. The purpose is in the preamble. The preamble reads that it's to prevent the increase of gun violence and further gun trafficking. Mr. Thomas is not a violent offender, and he is not, according to the facts on the record, a gun trafficker. He was reckless in leaving the gun, which he should have known or knew, but then left recklessly in the bed of his truck. However, the only person that he wanted to loose the gun to was not to some ruffian or someone trafficking in guns, but rather to the rightful owner of the gun. This is somebody who was unlawfully in possession of a firearm. But as we know from Oakes on down, possession cannot mean the implication of trafficking without material evidence to that regard.
But what do you answer to the argument put forward by your friend that the purpose of that legislation was not just about gun trafficking, but one of the ways to try to prevent gun trafficking is to insist on to try to regulate the mobility of guns amongst provinces. So your opponent is making that argument. What do you have to answer regarding the purpose?
We recognize that, perhaps drawing from the Controlled Drugs and Substances Act, that trafficking has to do with the object more than the person. So let's accept our friend's characterization of the purpose. That's about the mobility of guns. Still, the law is overbroad. If I can provide an example. Let's imagine Mr. Thomas was driving away from his friend's house, and he didn't know he had the rifle. He's not caught by the provision. You have to knowingly have the gun in your possession. However, just before reaching the border of the province of Bloor, he realizes he has the gun in the back of his truck. In that moment, he's caught. Let's even imagine that he was about to drive the gun back to the lawful owner's house, thereby furthering the purpose of the legislation to ensure that guns are not circulating. In that case, he would still be caught by the provision because he knowingly has a gun that he does not lawfully have the right to possess in his motor vehicle.
Well, why couldn't he just stop and call the police and say, geez, you know, got this gun? Have no intentions of having?
I don't mean to be too granular, Chief Justice, but let's imagine he did pull off on the side of the highway and then he would have to still get out of the car to not be caught by the provision. As long as the gun is in the car and he knows it, at least according to the provision as we have it, he would be caught by it. And it seems that he would have to either be outside of the car, which you would, I think, agree is less secure than being inside the car, or, God forbid, throw the gun out the window, and thereby we all agree that would be conduct that would be most unbecoming and would...
That would be next year's Grand Moot.
That would, exactly. I don't come here as a gun juggler, but rather as a mere public servant.
One follow-up question. Why can he not, I think what you're saying is the ability to drive and the license is sacrosanct, and so, we should not deprive him of that privilege within serious consideration. But why can he not, just hire someone to drive him?
He could hire someone to drive him. However, the question here is whether the law, and I see my time is up, if I can just answer your question briefly. The law is constraining his free movement, which engages charter protection. Whether it can be justified in terms of the costs that are put on him is a question for Section 1 we would submit. But in terms of the principles of fundamental justice and what they protect, here we would submit, in this case, it was arbitrary to deprive Mr. Thomas of that privilege, and we would ask the court to reverse the appeal and to restore the judgment of the Superior Court. I turn the podium to my co-counsel. Thank you for your time.
Thank you, Mr. Schwartz.
Good evening, Chief Justices, Justice. My name is Navia Sheth, and I will be concluding submissions on behalf of Mr. Thomas. Mr. Thomas is first and foremost a citizen of Flavel. He built his life on the promise of the right to move between the provinces of a united nation. But for the last 2 years, he has been tethered to his province of residence in direct contravention of the constitutional guarantees of mobility. For this reason, I will submit that the Firearms Safety and Accountability Act infringes unjustifiably on Section 6 of the Charter.
Ms. Chet, do you consider that when you say that he is restricted to his province, do you consider that he can leave the province? The only thing he cannot do is to be in the driver's seat of a car.
Absolutely, Justice. But we contend that interference with his ability to drive is an issue at both Section 6.1 and 6.2, and the functional ability to exercise the right is what's being impacted here. And so I will address your concern both at the issue of 6.1, which we contend this is an infringement on the right to remain, and at 6.2b, an infringement on the right to pursue the gaining of a livelihood. And finally, I will turn to why it is not justified under Section 1. So beginning with the 6.1 submission, which starts at paragraph 59 of our factum. We submit that interference with Mr. Thomas's ability to drive across the provincial border constitutes a violation of the Section 6.1 right to enter, leave, and remain in Flavel. And in order to accept this submission, you will have to accept two principles. First, the court's finding in Taylor that 6.1 protects the right to travel between provinces, and second, the court's finding in Brar that interference with a specific means of travel can interfere with this right.
So you, I think, were able to expect my position regarding Brar, but I think it's different because in order to use your passport to flew to a foreign country, then it's different than here. Here, your client is able to travel to the other provinces.
Right, so the follow-up is, you have a right for a passport as a citizen, but isn't a drive-in license a privilege as opposed to a right?
I will address your question first because I think it requires that in order to get to yours. So Chief Justice Tulloch, it's true that driving is a privilege and a passport is a constitutionally protected document. But our argument doesn't require you to constitutionally protect a driver's license. So we're not submitting, for instance, that someone without a driver's license has a constitutionally protected right to obtain one, regardless of their skill on the road. What we are submitting is where someone has a driver's license, and they are using that driver's license to exercise their Section 6(1) rights. The removal of that driver's license, is what constitutes the infringement. So there's no positive right, but there is a negative right not to be deprived of it. And now turning, Justice, to your question about the ability to travel and the functional issue here. Brar's reasoning is not based only on the passport issue. In fact, a wide swath of Brar takes up the question of whether the protection of a right should include protection for its exercise. And that's fundamentally what our submission here is, that without protection for the exercise of the 6(1) right, it becomes a hollow promise. That's exactly why flying is necessary to enter and leave the country. In Brar, the court acknowledged that Mr. Dulay had other options. He could have taken a boat. He could have certainly driven to the US and flown from there. Nothing prevented him from leaving the country. The issue was that flying was the only reasonable, realistic, and practical means of exercise of the right. And that, we submit, is the standard here. Reasonable, realistic, and practical.
And in the case of your client, is driving a car himself the only reasonable and possible way for him to travel from his province to another province?
We submit that it is. And the reason for that is both legal and practical. Since 1999 in White, the Supreme Court has recognized that in Flavel, driving is a necessity of life, particularly in rural areas, and we'd submit areas near the border, that lack these formal transit mechanisms where it's necessary to functionally exercise one's rights, to function meaningfully in society.
Counsel, may I ask, how much of this is tied up in the fact that he needs to travel between provinces for work purposes as opposed to personal or leisure reasons?
I'm glad you asked that because I think it draws on this important distinction between 6(1) and 6(2). So 6(2) is the protection for his work rights, his economic rights. It's a unique provision in the Charter that protects economic rights. 6(1), we'd submit, is a pure mobility provision. So it simply deals with his autonomy and being able to cross the border. Of course, a part of the consideration of the practical exercise of that right is how often he crosses the border. For Mr. Thomas, it's over once a week for work purposes, and frequently to visit family and friends, both of which he relies on his ability to drive his truck across the border. On the record, the only alternatives suggested by lower courts have been railways and airlines. And with respect, it is not reasonable, realistic, or practical for Mr. Thomas, who lives 25 minutes from the border, to take the Via Rail or an airplane.
What about Uber?
Justice, if it takes me 30 minutes to get an Uber in a major metropolitan city, I would say that for someone who lives 25 minutes from a border, where we have no evidence on the record that he lives in a major metropolis.
Is Falconer equivalent to Toronto in terms of the waiting time?
It's even worse.
Justice, you're from the rural area, not me. I'm sure you can speak to how difficult it might be to get around without a car. And so the core of this submission is that Section 6(1), if you accept that it protects the right to move between provinces, which we understand is contentious and will be before you in a few months, but if you accept that, then the functional exercise is what must be protected here. And for Mr. Thomas, that functional exercise requires the ability to drive. Barring further questions on Section 6(1), I'll turn to my submissions on Section 6(2)(b). These begin at paragraph 69 of the Appellant Factum. And Sections 6.2b and 6.3a are interlocking provisions. Together, they protect a citizen's right to be treated equally throughout the country, to pursue the gaining of a livelihood in any province without discrimination based on province of residence. By depriving Mr. Thomas of the ability to truck in Bloor, this act violates this right. In order to accept this submission, you must first accept that his livelihood right is engaged by the act, and then the act must discriminate primarily based on residence. We submit that both of these criteria are met here. Turning to why his livelihood is engaged, Black and the Law Society of Alberta, the first case to distill a test for Section 6.2b, is clear that the focus is on the person's livelihood of choice in their place of choice. For Mr. Thomas, that is trucking across the provincial border in Bloor.
Do you make a distinction between a trucker and a regulated profession, like a lawyer?
We don't, Justice. And the reason why is because Section 6.2b is broad in its scope. Because it specifically protects, as the court held in Black, even in the context of a regulated profession, that case was about lawyers, the court was careful to emphasize it is about livelihood of choice. It would be a poor provision, we'd submit, if it only protected those who'd been fortunate enough to be admitted into the professions. And indeed, the history of Section 6 also suggests protection from not just provincial barriers, but also federal barriers. In fact, even before the enactment of Section 6, there was protection since 1951 in Winter against provincial interference because of interjurisdictional immunity. The federal government had exclusive jurisdiction over citizenship. It's the enactment of 6.2b that recentered the focus of livelihood rights on the individual's human dignity and thereby also deprived the federal government of its ability to interfere with livelihood. Returning now to why the livelihood right is engaged, there's also an issue here that our friends raised about the degree of infringement required to engage the right. I'd remind the court of the holding in the Canadian Egg Marketing Agency case, which I'll call CIMA for ease of reference, that any attempt to create wealth in another province is protected by Section 6.2b.
But here he does not, I understand from the evidence that he is the owner of his trucking company. He is the operator also of the company, and he has 3 or 4 other drivers who can drive trucks. So I'm trying to find in the evidence where he lost or where he has been deprived of the opportunity to make a living with his truck business.
2 responses to this, Justice. First, very plainly, he can no longer drive his own trucking routes that he used to do 4 to 5 times a month at least. He also cannot drive himself to work. And while we concede he could perhaps take an Uber should one be available, it remains the case that some degree of interference exists there. And Black is clear that disadvantage is sufficient to engage this right. In that case, the quote, infrequent visits of lawyers from Toronto to Alberta was enough to engage the Section 6.2b right. The issue of degree, of amount of interference really focuses on whether this is primarily on the basis of residence, which I will turn to now. We submit that the driving ban discriminates primarily on the basis of residence because Mr. Thomas cannot work freely in Bloor due to his residence in Falconer. The comparison to make here for the purpose of the discrimination analysis is between residents of the province where Mr. Thomas is trying to work and non-residents like Mr. Thomas. That means it's between someone who is licensed to drive in Bloor, attempting to truck in Bloor, and someone who is licensed to drive in Falconer, attempting to truck in Bloor. Painting the comparison like this makes it clear why there is an issue based on residence. In Flavel, residence is inextricably tied to licensing. Residents can only possess one driver's license in the whole nation, which theoretically would allow you to drive anywhere, but it must be in your province of residence. That means, under the FSAA, Mr. Thomas cannot drive outside of his province of residence. This is the definition we'd submit of discrimination based on province of residence. But it's not enough to say there is some discrimination. The discrimination based on residence must be the thrust, the primary issue with the provision. And we'll concede openly that this is a valid purpose. Everyone agrees that gun trafficking is bad and we'd like it to stop. But in Flavel, discrimination has never been only about the purpose of a legislation. It also considers the effects. And even in the context of Section 6.2b, where the threshold is primarily based on residence, the requirement for effects-based discrimination can still invalidate legislation. Significantly impairing effects, like the court held in Black, those that have a severe and disproportionate impact on out-of-province workers, can constitute effects-based discrimination. The FSAA is...
Yeah, but the purpose of restricting gun trafficking and possession would you not agree that it overrides any kind of discriminatory effects?
We wouldn't.
Be it in or outside of the province?
We wouldn't, Justice, sorry.
Yeah,
Sorry,
think of the
Adam.
deleterious effects of guns to the society. And the word
Scourge?
slips me. Yeah, scourge, right? That it inflicts on the society.
I see your concern, Justice, but I would distinguish between the role of purpose in the discrimination analysis and its role in the Oakes test. At Section 1, it is perfectly legitimate to consider the importance of the objective, how effective it is in achieving its purpose. But for the purpose of the discrimination analysis, the purpose is just either valid or invalid. The question is whether the effects supersede that purpose in their impact. And when I turn to Section 1, I will certainly address that concern. But for the purposes of Section 6.2b, the issue is whether the effects outweigh that purpose.
But you say that the discrimination is primarily based on his residence.
Mhm.
What about if I tell you that it seems to me that it is based on his criminal record?
Well, Justice, we'd submit that that's essentially referring again to the purpose. Of course, in a criminal statute, there will be repercussions only for those who've committed the crime. But we don't strip Section 15 protections from criminals. We don't strip Section 3 protections. The Charter applies in effect and purpose here. And so the issue, again, remains on the effect of the provision. And maybe it will be helpful here to draw an analogy to SEMA, which also concerned federal legislation with a valid purpose. Without boring you with the details of the egg marketing issues, the issue in that case was whether a new producer in a province without a quota was disadvantaged in effect by legislation with a valid purpose. And the court in that case held that they weren't. The reason was simple. Any new producer in any province could apply for a license to market eggs. That's not true here. Mr. Thomas, by virtue of living in Falconer, cannot apply for a driver's license in Bloor, while someone who lives in Bloor can do that thing. This is the effective prohibition that SEMA discussed as rising to the level of effects-based discrimination. And mindful of my time, if there are no further questions on Section 6.2b, I'll move to my submissions on Section 1, which begin at paragraph 82 of the Appellant factum. And again, mindful of the time, I will focus my submissions here on minimal impairment, as I suggest that's where my friends and I don't see eye to eye. As a preliminary matter, we contend that less deference should be afforded to Parliament here. This is a straightforward criminal code amendment. The court has extensive expertise in balancing the state's interest in prosecuting crime against the rights of individuals. That's its bread and butter work. There are no complicated social values at play in this criminal legislation, unlike in Keegstra and Butler, where the core of the criminal provision itself concerned social values.
Well, the core, I would suggest, is to protect the safety and the lives of individual citizens within the state.
Yes, Justice, and it's a noble objective, but respectfully, not a controversial one. The reason the courts deferred in Keegstra and Butler is because hate speech and pornography are issues that are contentious within society, that implicate important social and political values.
So what about life, the life of individuals, victims?
We'd submit, Justice, that every criminal provision deals with the issues of life and security of person and liberty and balancing public safety against the legal rights of individual accused. And to adopt a position that requires the court to give deference anytime that is at issue would require the court to give deference on the entirety of the criminal code.
It's always a balancing act on the part of the court and on the part of Parliament.
Of course, Justice. And that's why we submit that under either a strict or deferential standard, Parliament had other options that would have been less impairing but equally effective. The core issue on minimal impairment is overbreadth. The law captures and punishes those beyond its purpose, those who are not violent, who are not gun traffickers. And to resolve this issue, Parliament could have either narrowed the scope of the offense or the severity of the punishment. As it stands, and this goes, Justice Cote, to your earlier question about adopting our friend's purpose. As it currently stands, the offense penalizes those who have no connection to interprovincial movement and those whose car might not even be moving at the time of being captured by the offense. There is nothing in the criteria for the offense that links this to trafficking. They could have narrowed the scope only to those who had the intent to traffic or who were actually trafficking. They could also have lessened the severity of the offense by removing the mandatory minimum so that there was correspondence between the blameworthiness of the offender and the degree of punishment.
We've already done that, though.
I see my time has lapsed. If I may briefly conclude.
Yes, you can.
Justices, being a citizen of Flavel means being a member of a national community that values certain freedoms. Freedom from state overreach, freedom of movement, freedom from discrimination. The Firearms Safety and Accountability Act undermines each of these freedoms for citizens like Mr. Thomas. And for these reasons, we respectfully request that this court allow the appeal and find the law to be unconstitutional. Barring any further questions, this concludes the appellant submissions.
Thank you very much.
Thank you.
So, we will now hear the Attorney General of Flavel. So, Mrs. Dalmau.
Good evening, Chief Justices, Justice. My name is Bryn Dalmeo, and together with my colleague, Ms. Emily Chu, we represent the respondent, the Crown. A tragic gun crime perpetrated by a trafficked firearm led the citizens of Flavel to demand that their elected officials enact stricter gun control laws. Flavel already had gun control legislation, but it was not enough to adequately address the twin problems of gun violence and gun trafficking by preventing the core underlying issue of the movement of unregistered guns. So Parliament acted. They called a royal commission to carefully evaluate the life-threatening issue of gun crime. Parliament then enacted a carefully tailored, evidence-informed statute directed at that very conduct element. While carrying a gun for which he could not produce a license, Mr. Thomas was arrested pursuant to Section 94(1) of the Criminal Code. Though he has asked this court to conclude otherwise, he was engaged in precisely the conduct that the impugned provision seeks to prevent, and so he was convicted and sentenced accordingly. Together, my colleague and I will make 3 submissions before this court. First, I will submit that the Notwithstanding clause was properly invoked. Second, Mr. Thomas' liberty interests were not engaged here. And third, Ms. Chu will make our final submission. The Firearms Safety and Accountability Act did not limit Mr. Thomas' Section 6 mobility rights. I will begin at paragraph 21 of the respondent's factum. Our friends have suggested that this is a case about freedom, but freedoms do not exist without limits in a constitutional democracy like Flavel. Section 33 of the Charter, which I will refer to as the Notwithstanding Clause, is an example of such a limit. The Notwithstanding Clause was properly invoked, and my submissions to support this conclusion rely on 3 pillars. First, the rule laid out in Ford. Second, the modern principles of statutory interpretation. And finally, the text and purpose of Section 33 within our constitutional architecture. First, in the landmark case Ford in Quebec, the Supreme Court articulated the rule rejecting substantive judicial review of legislative decision to invoke the Notwithstanding Clause. The court unanimously and unequivocally held that the enumeration of the section was sufficient. Nothing more was required.
So, but in this case, the Parliament decided to do more. What should we do with that?
Yes, Chief Justice Cote. Here, that Parliament provided more particularity than it was obliged to do does not negate the fact that it met the essential requirement of Ford by first enumerating Section 7. That was the threshold, and that was met. Again, that Parliament decided to provide additional information, we cannot negate then and exclude liberty from a coherent reading of the provision.
So you ask us to read in the word liberty.
Chief Justice Cote, we would rely on the additive phrasing at the end of the provision and all other rights therein. Our submission is that they ought not to refer to the principles of fundamental justice, which are not rights in and of themselves, but rather the right to liberty, which is the most coherent reading when we consider the provision as a whole. We would...
So if that's the case, then what's the harm if we were to tell Parliament to redraft the legislation so that it includes liberty, and then we stay the proceedings for 12 months or a year?
There would be no harm in that, Chief Justice Tulloch. We would, in this instance, ask there would be no exemption for Mr. Thomas' action because he still contravened the law, but Parliament could certainly amend their provision.
Are they obliged to amend it? Let's say that we follow you and you say that Ford requires only to mention the articles, the sections of the charter without saying more. So essentially we could focus on that and say we forget the balance of the sentence.
You could essentially, Chief Justice Cote, the essential requirement is that Parliament must have turned its attention to the severity of the right that was being overridden here. And all that the court required in Ford was that express declaration of Section 7. Nothing more was required. These additional details do not subtract from the fact that Parliament met its burden here.
But wouldn't you say, counsel, if they decide to go down the road of articulating the rights that are engaged, don't they have to do it correctly and completely? I mean, don't they have 2 choices? They either just say Section 7 and call it a day, or they say Section 7 and enumerate it properly?
Chief Justice Pargi, I would say yes and no to your question. What they must do is to articulate Section 7. And we don't wish to step into the minds of Parliament here, but our hypothesis is that Parliament simply intended to provide emphasis to life and security of person because this is a hybrid offense for which imprisonment is a sanction on the indictable arm. And so that they opted to provide additional detail, again, does not negate that they met the requirement, and it cannot be used to exclude liberty from a coherent reading of the provision. We would also suggest that the modern principles of statutory interpretation support this position. And our submissions here begin at paragraph 35. The context is critical. This was a life-threatening issue, and the elected officials of Flavel acted to protect the movement, protect their citizens against the movement of unlicensed guns. An interpretation that best accords with the intention of Parliament and the purpose of the legislation should be adopted here. The preamble outlines the scheme and the object of the FSAA. Parliament was committed to enacting stricter gun control legislation. It was not enacted in a vacuum. At the time the FSAA was adopted, Flavel already had prohibitions on the possession of an unauthorized gun. Despite this, gun crimes had risen by 17%, and the frequency of perpetrators using a trafficked firearm had doubled in a 4-year period. Gun crimes do not occur when lawful gun owners keep their firearms locked at home. Gun crimes occur when unlicensed, unauthorized guns are moved across the country, and that is the conduct Parliament sought to prevent.
But in this case, we had a driver who only fleetingly recalled that he even had a gun in his trunk. That doesn't give rise to gun violence, does it? Or gun trafficking, for that matter.
Justice Pargi, Mr. Thomas was reckless to the fact that he had a gun he should not have had in his vehicle. He was contributing to the potential problem. We do not know what could have happened to that gun if just left unattended in the back of his vehicle. So we take your point that he may not have had an intention to sell this gun, to commit crime with this gun, but he was reckless to the fact he was carrying a gun, and that conduct is precisely what Parliament sought to prevent. Finally, we would emphasize that it would be inconsistent with the purpose of the Notwithstanding Clause itself and a purposive interpretation of the Charter to subject the clause to substantive judicial review. We must remember that Section 33 was an essential provision included in the Charter to entrench a mechanism of parliamentary sovereignty and to remove legislation from the ambit of judicial review.
What do you make of the argument made by the appellant in their factum that when Section 33 was enacted, it was mainly to respond to a concern expressed by provinces in 1982 that without Section 33, provinces would not accept the 1982 Constitution. What do you make of that?
Chief Justice Cote, we think the text is critical here. The first word of the provision is Parliament. So the framers considered that the federal government too ought to have the ability to invoke the Notwithstanding Clause when it needed to give effect to its understanding of the Constitution and what was required. And we would also emphasize that the Notwithstanding Clause recognizes the role of the electorate as a central actor in a democracy.
But the fact that it was supposed to be used only exceptionally, does it give credence to the argument made by your colleague that strict construction is necessary, strict interpretation is necessary when we look at Section 33 issues?
No, Chief Justice Cote, it does not. Because this provision is a part of the Charter, and it must be read purposively with the Charter as a whole. And so if we start to interpret different provisions through different lenses, that interrupts the purposive interpretation that the entire document is meant to achieve.
But hasn't the override always been viewed as something very distinct and frankly controversial? I mean, we can't lump it in with the rest of the provisions of the Charter.
Justice Pargi, I take your point that we, perhaps as a society, have viewed this as a controversial issue. But again, the structure and the text, or the purpose, and the text of the Notwithstanding Clause itself, which we must assume that the framers put their minds to and intended to be in place, protects both the role of parliamentary sovereignty and the electorate within the democracy. In fact, in City of Toronto, the Supreme Court affirmed the position that any protection from legislation that some may view as unfair or unjust properly lies at the ballot box. It is subsection 33(3), the sunset provision, that ensures that the voter remains the ultimate accountability on the use of the notwithstanding clause.
But that reasoning can take us down some disturbing paths, no?
Justice Pargi, it is possible that there may be hypotheticals, but that is not the fact.
Yeah.
set
No, I
before this.
understand your argument.
So in simpler terms, you say to us, it's not the business of the court to review the use of Section 33, provided the specific articles are mentioned. That's it, that's all. We have nothing to do more than that.
Chief Justice Cote, that is what Ford, that is what principles of statutory interpretation, and that is what Section 33 itself would submit. But if you have concerns about the invocation of the notwithstanding clause, there was no limit on Mr. Thomas' liberty interests here. And I will move to these submissions, which begin at paragraph 39 of the respondent's factum. As we have now discussed with you at length, the full text of Section 7 provides that everyone has the right to liberty. But like all rights guaranteed by the Charter, the meaning of liberty must be understood in light of the interests that it was meant to protect. Liberty protects fundamental matters that are inherently personal or central to a person's dignity. At its core, liberty protects an individual from the state's ability to imprison or to compel attendance. It protects our ability to make fundamental personal decisions free from state interference. But liberty does not and should not extend to privileges like driving. The jurisprudence is very clear in this regard. Possessing a driver's license is not a constitutionally protected right. It is a privilege. Nearly 40 years ago, the Supreme Court emphasized that while it may be convenient to refer to the ability to drive on a public highway as a liberty, it is not a fundamental liberty like the ordinary right of movement of an individual. Rather, driving is a regulated activity that is controlled for the protection of life and property. We recognize that an interprovincial driving ban may impact a person's lifestyle, but that it becomes more difficult to travel across the country does not rise to the level of a breach of a charter right. To extend the protection of Section 7 to a privilege like driving would be an unnecessary extension of the interests that it seeks to protect. But whether we frame driving as a right or as a privilege is not determinative here. Interprovincial driving simply does not rise to the level of a legal breach. In their written materials, our friends have actually provided a very helpful example at paragraph 44. They describe the state's power of coercive control to keep a person within political borders, and that would engage Mr. Thomas' liberty interest. But that is not what is happening here, and the interprovincial driving ban cannot reasonably be portrayed as such. There is no point through the duration of his sentence that he is not free to leave the province or the country. He has not been confined, and his free movement has not been prohibited.
So let me ask you a hypothetical question. Let's say that I'm living in a rural place, and the next hospital is in the other province, and it is 45 minutes. I'm alone at home with my baby. My baby is sick, and it is urgent that I go to the hospital, and the only way I can get there is to use my car. Do you recognize that my liberty, my right to liberty is infringed?
Chief Justice Cote, in that instance, it would be a very difficult situation, and we don't minimize that. We would submit that there are alternatives. Again, you could call an ambulance. You could use an Uber, as suggested to our friends. There are alternative options for Mr. Thomas to travel, and this simply is not rising to the level of a breach of his liberty rights.
Would you say, counsel, that if we accepted that the 6-2 mobility rights in connection with the appellant's work are engaged, should that inform our analysis under this charter right?
Justice Pargi, our submission is that they are two distinct analyses. And here, under Section 7, we are concerned with the free movement of the individual, not with his ability to obtain a livelihood. And my colleague, Ms. Chu, will make our submissions on Section 6-2.
Okay, But you wouldn't accept the suggestion that the right to move for the purposes of earning a livelihood has to factor into the Section 7 analysis somehow. You view them as distinct.
We do, yes. Speaking of distinct, we would also like to distinguish our friends' reliance on Sahaluk, a divided lower court decision that considered the suspension of a driver's license in a criminal context. We would remind the court that Charkawi instructed that whether or not the Section 7 protections apply do not depend on a distinction between the area of law, but the severity of the consequences. And here, the severity of the interprovincial driving ban simply does not rise to engagement of a liberty right. But should you have concerns, perhaps your hypothetical that you posed to us, any engagement of Mr. Thomas' liberty is done in accordance with the principles of fundamental justice. And I will turn to those submissions at paragraph 49. When considering the purpose of the impugned provision, it is critical that the FSAA not be reduced to a, quote, gun trafficking law. This act reflects Parliament's intention to enact stricter gun control legislation. The existing prohibitions were not adequate to impact the rampant gun violence in the country. Our friends have conceded that the law is not arbitrary, nor is it grossly disproportionate, but would suggest that here it is overbroad, and it is not. A law is overbroad when it captures conduct that is unrelated to the objective. And our friends have suggested to you that it is unrelated because Mr. Thomas is not a gun trafficker. With respect, this narrow interpretation ignores the mechanism by which guns are trafficked. It was the increased movement of guns, underlying gun trafficking and leading to the increase in gun violence that was the very problem that prompted Parliament to amend the criminal code.
But surely, counsel, this was clearly an inadvertence on the part of the appellant. One, the gun did not belong to him. Two, the gun, was it not a licensed gun for the owner that inadvertently left it in the car? And three, there was absolutely no intent on the part of the appellant to be trafficking in guns.
I'll answer the last part of your question first, Chief Justice Tulloch. To import an interpretation, to import an intention to traffic, to sell, to distribute the gun would run into the specific evidentiary difficulty that the Supreme Court warned against in Bedford, that it becomes difficult to prove the intention could lead to traffickers escaping liability. Here, Parliament set
not for criminal judges or lawyers or prosecutors.
Fair. However, that was the concern that the court recognized in Bedford, and we think it is apt here. We would also rely on the definition of trafficking in the CDSA, for example, which simply requires the transfer or the transport of a substance.
But there's usually circumstantial evidence surrounding the trafficking that informs the intent of the accused.
Justice, noting that
There still needs to be some level of mens rea.
Yes, and here, Chief Justice Tulloch, there was a level of mens rea. Mr. Thomas knowingly possessed the gun as found by the trial judge, and that met the requirement of the act. And seeing that my time has elapsed, barring any further questions.
I have one question. I'm going to give me an extension. If your position is that there was no infringement of Section 7 rights, why Parliament is fighting so hard on the use of Section 33? Because when a legislature decides to use Section 33, it is because they have a pretty good idea that there may be a violation of a charter right.
Yes. And if I may briefly.
Yes.
Thank you. Our submission, Chief Justice Cote, is that Parliament again recognized that this was a hybrid offense. And under the indictable arm, imprisonment was a sanction, and as such, his liberty interest would certainly be engaged at that point.
Okay.
Barring any further questions, that concludes our submissions on Section 33 and 7, and Ms. Chu will make the remainder of our submissions tonight.
Thank you.
Thank you.
Good evening, Chief Justices, Justice. My name is Emily Chu, counsel for the Respondent, the Crown, and I will be concluding the Respondent's submissions by addressing the Firearms Safety and Accountability Act's alleged infringement of Mr. Thomas's Section 6 mobility rights. Justices, as you just heard from my co-counsel, the FSAA is sensible legislation, carefully crafted and tailored to meet the pressing challenges of gun violence and gun trafficking, which have imperiled the lives of the citizens of Laval. And to that end, Section 94(2)B of the FSAA does not infringe Section 6, either under Section 6 subsection 1 or Section 6 subsection 2B, even using an expansive reading of those rights as suggested by my friends. However, should this court disagree with us and find either infringement, this legislation is saved by Section 1 as a justified limit. I will begin by first discussing the alleged violation of Section 6(1). These submissions begin at paragraph 71 of the Respondent's factum. Justices, the Act does not violate Section 6(1), which is the right to enter, remain in, and leave Laval, because the appellant's construction of Section 6(1), relying on two authorities, Taylor in Newfoundland and Brar in Canada, stretches the right beyond its purpose and its plain language. My friends argue that the right to move interprovincially is a component of Section 6(1), which was a key holding in Taylor and Newfoundland, a decision from the Supreme Court of Newfoundland and Labrador. However, Justices, Taylor is a lower court case which has not been widely affirmed nor seen as persuasive authority anywhere else. And here we suggest that its persuasiveness is similarly limited because its holding and its protection of interprovincial mobility under Section 6(1) is ultimately incongruent with the purpose of that right, which is to preclude legislation providing for the exile, banishment, and deportation of citizens. Justice Laforêt said as much in United States and Catroni, where he stated that the central thrust of the right is against exile and banishment, the purpose of which is the exclusion from the national community. And so while it is true that charter rights must be interpreted purposively, we must also be conscious of guidance from the Supreme Court of Canada in Big M Drug Mart, for example, where the court reminded us to interpret rights in light of the interests they were designed to protect. And this right is about protecting the pure mobility right of citizens to enter, leave, and remain in the federal state and the country.
So is it your suggestion then, counsel, that there is no right to move about the country freely? I can't get on a plane tonight to Saskatoon?
Justice, you may do so. It is not our submission that Taylor's reasoning is uncompelling, or that it may be compelling in other contexts, that perhaps Section 6 more broadly protects such a pure interprovincial mobility right. We do submit, though, that Taylor's placement of this right under Section 6(1) is ultimately an ill-suited place for this right. But Justices, if you are convinced that Section 6(1) or Section 6 more broadly protects such a pure interprovincial mobility right, this theoretical right is still not violated in this case because Mr. Thomas nor anyone else convicted under this act are prohibited from traveling interprovincially. Thus, the court must further agree with the appellant that driving a motor vehicle interprovincially is constitutionally protected. But the authority the appellant relies on, Brar and Canada, to make this claim is ultimately too limited by its context involving passports and overseas commercial air travel to support a broader principle that any mode of transport used to effect one's Section 6(1)'s rights is constitutionally protected, or that such a principle applies easily to this context involving driver's licenses and motor vehicle travel. So in Brar, the appellants were placed on a no-fly list, which made it impossible for them to fly commercially. The court found a violation of Section 6(1) in this case because foreclosing commercial air travel to the appellants left them with no reasonable way to exercise their passport, and if they chose to travel overseas. So this decision was twofold, and both reasons are not applicable here. The first is that there is not the same sort of impetus for the court to find that there must be at least one reasonable mode of transport to exercise one's Section 6.1 rights here, because BRAR involved passports, which is a constitutionally protected document. A driver's license, as the courts have repeatedly held, is not constitutionally protected. Putting that aside, even in this case too, there are reasonable and practical alternatives available to driving in a way that there was not for commercial overseas air travel in BRAR. Carpooling, taking buses, taxis, or Ubers, if they are available to Mr. Thomas, are much more reasonable alternatives to driving than would be the case in BRAR, which was taking a boat if one could not fly overseas.
But if he can use these other means, Mr. Thomas, like to be with a friend in a car, provided he is not in the driver's seat, does it really further the purpose, the fact that I say, you, Mr. Thomas, you cannot drive? If I want to traffic guns, I will find a way. I can say to my friend, let's do this together. You'll be the driver and I will be the passenger. So I'm wondering how it furthers the purpose of preventing the mobility of guns, even if I accept your definition of the purpose, how it can prevent the mobility of guns between provinces.
Yes, Justice. On your point, it is important to remember the evidence with which Parliament enacted this law, and which comes from the Royal Commission. And the Royal Commission's report demonstrated a link between increased gun crime and the interprovincial movement of guns, specifically in motor vehicles. So while the frequency of perpetrators using a firearm from a different province than where the crime had occurred had doubled, gun crimes were increasing across the country, and at the same time, the frequency of roadside detention on highways revealing an unlawful possession of a firearm also increased by 40%. And so this goes a little bit to the rational connection of the law, but if you are transporting unauthorized guns in a motor vehicle as Mr. Thomas was, you are engaging in precisely the kind of behavior that the report raised concerns about. And to the extent that the law gives Mr. Thomas the ability to travel in a car but in the passenger seat, ultimately reflects Parliament's intent to minimally infringe rights, if any, at all in this legislation, and that I will return to when I get to Section 1. So to conclude on Section 6.1 briefly, to put a bow in it, Chief Justice Cote, you asked my co-counsel about someone in a rural situation and would be subject to this penalty. It is the case for people like you described there, for whom driving is in many ways their primary or only mode of transportation, who have had their full license suspended as the result of a drunk driving conviction, for example. In those cases, the courts have not typically recognized a violation of any charter right, let alone under Section 6.
Yeah, because the restriction is really linked with, like, somebody who is convicted for impaired driving. I can understand that that person cannot drive after, because that punishment is directly linked to the ability of the driver, which is not the case here.
Two responses to your question, Justice. The first is that in many ways, this legislation is targeted at restricting Mr. Thomas's movement, for example, in movement in a motor vehicle, in the same way that a driver's license suspension after a drunk driving conviction is targeted at restricting that person's movement in a car. But the second point I will bring up here is that driver's licenses have been suspended as part of a deterrent penalty in other contexts, such as in family law, for example. So the Family Responsibility and Support Arrears Enforcement Act in Ontario allows for a driver's suspension as the result of a failure to pay arrears in a family law context. So there are, and in those contexts, again, charter rights are not seen to be infringed in those cases. Once again, demonstrating that restrictions and suspensions on driver's licenses are not seen to engage constitutional scrutiny in a way that they would in the context of a passport, for example. Barring any further questions on Section 6.1, I will turn to my submissions on Section 6.2b, which begin at paragraph 77 of the Respondent's Factum. Justices, The Act does not violate Mr. Thomas's rights under Section 6.2b, which is the right to pursue the gaining of a livelihood in any province. In order to find a violation of Section 6.2b, the appellant must show, as a threshold consideration, that Mr. Thomas's ability to pursue his livelihood is engaged by the statute. If the threshold is met, the appellant must then demonstrate, per the Supreme Court of Canada's analysis in SEMA, that 1, there is a differential treatment between residents and non-residents, and 2, the legislation discriminates among persons primarily on the basis of residence. The appellant has failed to demonstrate that, first, Mr. Thomas's livelihood is engaged by the statute, and second, that the Act discriminates primarily on the basis of residence. Beginning with the question of livelihood, Mr. Thomas's livelihood is not engaged by the Act because Mr. Thomas's right to pursue his livelihood as owner and operator of Truck Pro is not rendered, in the words of SEMA, essentially illusory. Section 6.2b has typically been engaged when an individual is effectively unable to practice most, if not all, functions of their job. But the bulk of Mr. Thomas's day-to-day employment is unaffected by these mobility restrictions. Mr. Thomas's livelihood is as owner and operator of Truck Pro, of which interprovincial driving is a part. And while he currently fulfills a handful of interprovincial deliveries and occasionally visits his head office in the neighboring province, both activities can be easily delegated or completed through alternate means of transport. There is a scenario where even after facing conviction, Mr. Thomas can still ensure the fulfillment of all the same professional duties as before, while still maintaining the same job. And in no way does that engage livelihood as per the jurisprudence.
Yeah, but if he's an owner of a trucking company that deals with transportation between provinces, surely you can, the inference is that it is going to cause some level of hardship if he has to hire someone else to do his driving for him, right?
Thank you, Chief Justice Tulloch. In response to your question, certainly, I think it is fair to suggest that the level of infringement with Mr. Thomas's livelihood is perhaps debatable, and you may recognize it to find it more severe than we do. But nevertheless, we do submit that the appellant cannot demonstrate that the Act discriminates primarily on the basis of residence, in either purpose or effect. So in no way is Mr. Thomas discriminated against or it made his job experiences a harder time in completing his job because he is a resident of Falconer. It is because he transported a gun for which he could not produce a license in a motor vehicle across provincial borders. And stopping this kind of behavior is the pith and substance of the law.
But if he had transported the gun, and I'm using that word loosely because I'm quite concerned that Mr. Thomas didn't have any meaningful knowledge that the gun was in his trunk, but let's just pause that for a moment. If he did transport the gun and he lived in Bloor, he would not be facing the same issues he is now facing in terms of getting to work and earning an income. And that concerns me greatly. That to me seems like a distinction based on his place of residence.
Justice Pargi, we do hear your concern, and we do not, it is not our submission that there is no differential treatment on the basis of residence between a resident and a non-resident under this Act. That's why we are not challenging the first prong of the SEMA analysis, which just speaks to the existence of such differential treatment. But what we do contend is that the law does not primarily discriminate on that basis. And to the extent that you are concerned about the effects of this legislation, which my friends focused on, to the extent that Mr. Thomas experiences any differential treatment, in effect, is acceptable because, as SEMA stated, resulting difference between residents and non-residents is fine if it is incidental to a valid, wider legislative objective. And so, in this case, McKinnon might be helpful in this regard, which SEMA cited with approval. So in McKinnon, a fishery management plan barred non-residents from fishing in certain areas, which made it impossible for the applicant, who was a fisherman from Nova Scotia, from making his living in Newfoundland. And the court held that that was acceptable in that case, that differential treatment between the Nova Scotia fishermen and the Newfoundland fishermen, which I might add was more clearly on the basis of residence in that case, because it was incidental to the best interests of the fishery as a whole that fishermen be confined to their traditional grounds. And here, whatever differential treatment Mr. Thomas experiences, he cannot drive interprovincially because it is incidental to the best interests of Flavel that to limit the interprovincial movement of guns, and not primarily because he is a resident of Falconer. Barring any further questions on Section 6.2b or Section 6 more broadly, I will now turn to my submissions on Section 1, beginning at paragraph 89 of the Respondent's Factum. And I preface my Oakes analysis with 2 points at the outset, Justices. The first is that courts have repeatedly demonstrated a willingness to find justified limits on Section 6. It is not a right like Section 7, for example. Courts have even found justified limits under Section 1, even in the context of restrictions on passports, which, again, have attracted historically more constitutional protection than a driver's license does. And second, Parliament is owed deference here. Gun trafficking and gun violence, as they have manifested in Flavel, are complex social issues, abstract and intangible problems outside the ken of the courts, warranting deference. And while it is true that criminal law typically attracts a stricter Oakes, this is not always the case, and courts have employed deference even when criminal law is invoked in other cases, and they've used deferential approaches in other in other Section 6 cases as well. Beginning with rational connection, at this stage, the government need only show that it is reasonable to suppose that the limit may further the goal, but not that it will do so. And to return to your question, Chief Justice Cote, from several minutes ago, the Royal Commission's evidence, again, shows that there is a link between increased gun crime and the interprovincial movement of guns, specifically through motor vehicles, making it rational for the government to target this conduct. And on minimal impairment, in evaluating this, the court must ask whether there is an alternative, less drastic means of achieving the objective in a real and substantial manner. And if I may begin by discussing what my friends quibbled with, which was the mandatory minimum term of the interprovincial driving ban, and why 3 years, essentially. So all that is required at this step is that 3 years be reasonably minimally impairing. And the 3 years was arrived at, again, after Parliament carefully considered the data for these issues in Flavel, which developed over the course of 4 years. And if the goal is to stop the interprovincial movement of guns, people must be prevented or deterred from doing so for a period of time. And the 3-year minimum accomplishes that by raising the stakes for people to not engage in this conduct.
But in this case, doesn't it just merely stop Mr. Thomas from accidentally transporting guns for 3 years? I mean, it comes close to a strict liability offense the way it's been enacted, and then it has sort of a 3-year-long shadow that it casts over people caught by its requirements.
Justice Pargi, I do acknowledge that there are aspects to Mr. Thomas's case which are sympathetic, but that does not mean that the law is overbroad or grossly disproportionate in this case. Ultimately, the law does have the mens rea requirement of knowing. To the extent that you have an issue with the reckless finding at the trial level, that is ultimately not at issue before this court because Mr. Thomas is not challenging his conviction. And so the broader constitutionality of the law suggests that because the law has a mens rea of knowing, this does not mean that any time someone doesn't know that they have a gun in their vehicle, they would be captured under this legislation.
Right.
And noticing my time, if I may turn to one final argument under minimal impairment.
Yes, I will ask you to conclude because you have 2 minutes.
Okay, thank you. So to conclude on minimal impairment, I would also point to the drafting of the penalty and the legislation more broadly as reflecting Parliament's concern to carefully tailor this legislation and minimize any resulting infringement. So my friends suggest in their written materials that the government could have enacted less than a complete ban of interprovincial driving. But We suggest that the government already followed that guidance by not imposing a full driver's license for the entire duration of the penalty. So once that initial 30-day suspension is up, a person thereby regains their ability to drive wherever they want in their own province, save for the ability to do so interprovincially. And that, justices, is the minimum restriction necessary the government needs to accomplish its goals in a real and substantial manner. And that near full restoration of one's driving privileges shows that this is not a blunt instrument, but in fact a carefully tailored piece of legislation. And noticing that my time is up, barring any further questions, on balance, we submit that the FSAA is a proportionate limit justified under Section 1. Barring any further questions, as I already said, I rely on my factum for the balance of my submissions, and the respondent respectfully asks that this court dismiss this appeal. Thank you.
Thank you.
Thank you.
So, I was about to ask if there was a reply, but I assume there is none. So if I don't follow the rules, I think it is the time now to give our comments on the performance of the lawyers. So I will just say a few words, and I will let my colleagues to give their own views. But I must say, and this is not the first time I say that, because I've presided many moots since I've been at the Supreme Court. And I will repeat it here because you were extremely well prepared. And I must say, better than some of the lawyers that who appear before the Supreme Court of Canada. And I must say that before being a judge, I've been a litigator for 34 years. And I am flabbergasted, but positively flabbergasted by your performance. I want to congratulate the four of you. We are going to take the case under advisement, so we'll render our judgment in a few months. But I want to congratulate the four of you, and also want to congratulate the coaches and the people who invented that case. It was extremely well done. And we read the factum. And again, the factums are extremely well written. It's very clear, no repetition, because at the Supreme Court we receive 40-page factum with a lot of repetitions quite often. I see one of my law clerk who is here, Emma, and she has to read that, and I think she will share my views on that. And also, you were very well prepared. When I was teaching trial abilities and appellate abilities, I was always telling my students, you know, advocacy, you need some talent to do a good advocacy. But it is also, talent does not suffice. You need to be very well prepared, and you were, because you were able to deliver your submissions without even reading your notes. It was very clear in your mind. What I like too, and it is very important for us at the Supreme Court, and I will let my colleagues, your opening statements. When you watch the hearings before the Supreme Court of Canada, you will notice that some of my colleagues, they interrupt the lawyers 10 seconds after the case has started, and they interrupt the lawyers in their opening statement. I'm against that, because I think that the 2 or 3 minutes that the lawyer takes to give the opening statement, it is very useful. First of all, it is good to evacuate your stress, because when you argue a case, it's normal, and it's good to be under stress when you begin your argument. And second, it is good for the judge to listen to the opening statement. Speaking for myself, I like to know the roadmap which is going to be followed by the lawyer. And in your case, the two teams, it was clear, I'm going to argue this, my colleague is going to argue the other thing. So that was very good. I could go on and go on, but, and also I like the way you answer. I was not very nice with my questions, but I just wanted to see if you would be able, and that it went very well. And I really like Mr. Schwartz, your sense of humor. And you answered our questions very well, very clear. And you, Emily, for instance, when you distinguished Taylor and Breyer, it was excellent because the appellant's argument was based a lot on those two cases, and it was great for you to go there and to focus on that and to say, hey, it does not apply here. So maybe Mr. Taylor is in danger, according to... But I just want to say congratulations, and I encourage you to file an application to become a law clerk at the Supreme Court of Canada. Thank you.
So on that last note, I think you got to come to the Court of Appeal first. Anyway, you know, without repeating a lot of what my colleague has said, you know, I'm totally impressed. I think all four of you were just incredible advocates. You gave us a pathway as to where your oral arguments were going to be, and you were very well prepared, not only in the law, but also in, you know, anticipating where we were going with some of our questions. And I think that just shows a level of sophistication that is, you know, it's incredible for students. And I also agree with my colleague that you're equal to and better than many lawyers who appear before us at the Court of Appeal. You know, I've been a judge now for 22 years, and you guys are outstanding in every way. And, you know, I don't want to belabor it. All of you, each of you, were excellent in your presentations, and I certainly encourage you to apply to us.
We like to have the clerks trained first by the Court of Appeal of Ontario, and after that.
Yeah. One of my former law clerks is one of your Meshach, right? He's one of your coaches, I understand. So, you know, you'll be in good stead if you come to the Court of Appeal.
Well, I will add that the best place to clerk is the Superior Court of Justice, where you get not the lofty appellate work, but the down and dirty, real life, practical trial motion application work. But joking aside, Chief Justice Tulloch used the word outstanding, and that is exactly the word I've had going through my head for the last while. All four of you were excellent, smart and thoughtful. You had a real poise. You did not speak too quickly, which it's very easy when you're nervous to just go, and nobody did that. Answered questions really well, dealt with hypotheticals very well, which is tough because hypotheticals take you off your game plan, and you want to give a smart answer, but you don't want to concede too much, and you're like, but you all dealt with all of that really well. You talked about other cases that underscored your point very well in your responses. You conceded things where it was sensible to do so, which also makes you very credible to the judge hearing you. The facta were excellent. The problem was excellent. Your oral submissions were outstanding, and you should all be very proud. I think we all know how much work you must have put into it. So huge congratulations. Very well done.
Thank you all for joining us for this year's Grand Moot. We hope you all enjoyed tonight's event as much as we and our four incredible mooters enjoyed preparing for it. Drafting the problem and the factums is a very difficult task, especially since a few months ago, Mr. Thomas did not in fact exist. So with regards to all of the drafting that we did, we'd like to thank our professor advisors that helped us create the arguments for the FACTA as well as draft the problem itself, Professors Schaefer, Stacy, Stewart, and Bedard-Ruben. Your guidance was instrumental in crafting a challenging problem, refining the mooters' arguments, and preparing them for tonight's panel. Thank you for taking the time to make tonight an incredible success. We would also like to thank each of the mooters for working so hard over the last few months to prepare for tonight. The amount of work that goes on behind the scenes is truly staggering, and all of that work is done with the purpose of making the Grand Moot an entertaining and impressive showcase of the oral advocacy skills that U of T has to offer. I think I join this entire room in saying that your submissions were truly excellent. If we could get a huge round of applause for tonight's mooters.
Of course, this event would not have been possible without the informed and thought-provoking questions from the members of our panel. A very, very heartfelt thank you to Justice Cote, Chief Justice Tulloch, and Justice Pargi for taking the time out of your undoubtedly busy schedules to be here with us this evening. Our law school community is incredibly fortunate to have you joining us for the marquee event showcasing our commitment to oral advocacy. Please accept these gifts as a token of our appreciation. Finally, thank you once more to our sponsors, McCarthy Tetro. McCarthy's continued support for this event is what enables it to happen every single year. We are immensely grateful that they've chosen to dedicate their time and their resources to the Grand Moot once again. We'd like to invite Daryl Cruz from McCarthy Tetro to say a few words before concluding our event for the night.
Thank you very much, and Justices, thank you. It's great to be here. I can say that this is a personal thing for me because the first time that I was in this room was as a first-year law student in 1987. And being at the Grand Moot as a first-year student inspired me on the path that I'm on today and that I went down over all these years. So a lot has changed in that time. And we didn't have Uber, for one. But one thing hasn't changed, and that's the importance of advocacy. And all of you did an amazing job today. Congratulations, and to everyone who supported the moot all the way through. But you know, when you do a moot, you're dealing with a problem that's been made up. And when you get into practice and you work on something where real people's lives are at stake, it becomes even more thrilling and more exciting. And I'm sure you're all going to experience that. As I was listening to this, I thought back to one of the submissions included reference to the Black & Company case. So Black & Company was a case brought by our law firm to enable law firms to work nationally. And so we went to the Supreme Court of Canada to ensure that McCarthy Tetro could be formed. And so Black & Company merged with McCarthy & McCarthy and then Clarkson Tetro. And we became a law firm in part because of that case. So these cases are real. They impact on people's lives. And you're going to enjoy it even more when you get to do this for real. So our firm has been sponsoring this moot since before my time. So when I sat here as a first-year student, McCarthy's was a sponsor, and we have been all the way through, and we hope to be for many more years to come. And we do it because we believe in advocacy, and we think that it's important for everyone to see it and to join a profession that really is a fantastic profession. So you can tell that I've been around for a while too, and I can say that I love my job today as much as I did when I was a student in that first-year class, and I'm sure all of you will too. So again, thank you. We're proud to be here. We're proud to sponsor the moot. We hope to do so for a long time. I would say that forget about the clerking. Join a law firm. Thank you.
I want to say something to Monsieur. They should not forget about clerkship before joining a law firm because you know what? When you have clerks, especially at our court, you get a signing bonus when you join a firm.
So that's the only thing I'll agree with her on.
So the court is adjourned
It is.
until next year. Thank you.
I'd like to welcome you all to the reception that will be happening in the Rowell Room. So please join us for the reception. Thank you.